right, so we're looking into the Ontario Municipal Act. Now, this operation of law exists in each and every province going across Canada. It also exists in every state of the United States of America. The same operation of law. And it says municipality means a geographic area whose inhabitants are incorporated. Body corporate. The inhabitants of every municipality are incorporated as a body corporate. So what this is showing us is that we started under the designation of inhabitant. That was the designation in law. But afterwards, that inhabitant was incorporated into the corporate body, into the municipality. And as being incorporated into the municipality, the inhabitant became an officer of the corporate body. Now, some will teach, and some will make a video and tell you that you are a corporate body. You've been considered to be made into an independent corporate body. But that's not what it's saying here. It's saying that you are incorporated as a corporate body into the municipality, into the corporation of the municipality. Not that you are a corporate body yourself, but you are incorporated into a corporate body. Looking into the Criminal Code of Canada, municipality includes the corporation of a city, town, village, county, township, parish, or other territorial or local division of a province, the inhabitants of which are incorporated. So the inhabitants of a city, of a town, of a village, of a county, of a township, of a parish, or any other local division of the province, those inhabitants are incorporated into the corporation. And if you're incorporated into the corporation, then you are an officer of the corporate body. It goes on to say, or are entitled to hold property collectively for a public purpose. So the inhabitants which are incorporated into the corporation are entitled, not obligated, but entitled to hold property collectively for a public purpose. So in law, they are declaring that the property that you own, the home that you own, is being held collectively for a public purpose. Now notice one more time that they used the designation or the word entitled. It didn't say obligated, but entitled. Entitled means an entitlement, and it produces an operation of law that allows you or disallows you depending on what you choose. So under the Criminal Code of Canada, right, the police can see you as either holding your property for a public purpose or not. Now, if you go into a statutory court and you open up your ears and listen to what's being said, the judge, when dealing with you, he's going to claim that your property, your home, is a residence, and that you are a resident at that residence. And when anyone starts talking with those terminology, well, they're starting to talk from the point of view of you holding your property collectively for a public purpose. They are trying to address you. They are trying to designate you as an officer of the corporate body. Therefore, you are resident in the residence. And under the Criminal Code of Canada, when we look at the definition of dwelling house, it means the whole or any part of a building or structure that is kept or occupied as a permanent or temporary residence. So if you refer to your home as a dwelling house, and if you allow the police to refer to your home as a dwelling house, then what they are referring to is a residence. And how they are dealing with you, they are dealing with you as an incorporated officer of the corporate body. And they are dealing with you as your property is being held collectively for a public purpose. Criminal Code of Canada, public stores. Public stores includes any personal property that is under the care, supervision, administration, or control of a public department. All right, so go and try and add an attachment to your house in your local municipality without applying for a license or a permit. Try and do some upgrades on your property. And what's going to happen? Well, they're going to send an inspector to your house, right? And they're going to tell you, you got to stop. You didn't apply for a permit. You don't have the proper regulation. You don't have the proper approval. Therefore, your property is under the care and supervision and administration and control of the public department. What about your motor vehicle? Is it under the care, supervision, administration, and control of a public department? Oh, yes, it is, right? The same department that you went and applied for a permit. The same department that you went and registered that vehicle. What about your fishing equipment? What about your hunting equipment? Your fishing property, your hunting property. Is that under the control and care and supervision of a public department? Did you go and apply for a license and a permit from a public department? And in so doing, you placed your personal property under the control of that public department. When you think about it, right, and you analyze it, right, then most everything that you own, most everything that's considered your personal property is actually a public store in law. They consider it a public store in the law. And look how wicked the legislators were. Look how evil the legislators were. Public stores includes any personal property of any person in the service of a public department. All right, so you have been incorporated as a body corporate into the local municipality, which is a public corporate body. And therefore, you are a person in the service of a public department. So by default, all your personal property is under their supervision, is under their care, their administration, and their control. That's how tight the law is. That's how tight their wickedness is. That's why when you deal with the police officers across Canada, they're under the same operations of law that are transpiring in the enactments. They are coming at you. They are treating you. They are designating you, whether willfully or unwillfully, as an inhabitant which is incorporated into the corporate body. And therefore, all your personal property is being held in a public store. And your dwelling house is your residence as the officer of the corporate body. And because they treat you as such, then you are under the care, supervision, administration, and control of the public departments. And the police officer represents the public department. Therefore, they are attempting to enforce the policies or the enactments or the duties or the obligations of the statutory creature upon you. Now let's talk for a minute here about land and about homes. Remember in the criminal code, right? It said that we are holding our property collectively with others. But it doesn't define for us, well, who are these others that we are holding our property with? The Land Titles Act of Ontario. And this same operation of law works right across Canada in each and every province. The subsequent operation of law found here is found in your enactment for your province. Estate of first registered owner with absolute title. The first registration of a person as owner of land in this act Okay, hang on. Why are they making a designation? Why are they making a distinction by declaring the first registration? So there's more than one registration? That's what the law is saying, right? Otherwise, why would it designate the first registration if there was not subsequent registrations? So the one who has the first registration to the land, your home sits on a parcel of land, does it not? The one who has the first registration is the one who has absolute title. The first registered owner with absolute title. Now, having absolute title gives to this person the estate in fee simple in the land, together with all rights, privileges, free from all estate and interest whatsoever. Free from all estate and any interest in that land or in the home on that land, including estates and interests of Her Majesty that are within the legislative jurisdiction of Ontario. So the one who has first registered ownership, the one who holds absolute title to the land, is free from Her Majesty's interest. Building Code enactment on the bottom of this page. Building permits. No person shall construct or demolish a building or cause a building to be constructed or demolished unless a permit has been issued. Role of various persons. It is the role of every person who causes a building to be constructed to cause the building to be constructed in accordance with this act and the building code and with any permit issued under this act. All right, so they have the power and the authority to issue a permit under the act. And where did they get this power from? The Financial Administration Act, Article 19. The governor in council may, on the recommendation of the Treasury Board, by regulation, prescribe the fees or charges to be paid for a right or privilege conferred on, by, or on behalf of His Majesty in the right of Canada by means of a license, a permit, authorization by the persons or classes of persons on whom the right or privilege is conferred. So the subject or the player that is getting the permit or the authorization on behalf of His Majesty is a class of person. That's the one who's getting it. And under the Building Code enactment, again, it's a statutory creature, a class of person who needs to get the permit issued, who needs to have a permit issued to them under the enactment, because His Majesty has declared this, and therefore you must pay for the privilege, you must pay for the right. And when you go to the local municipality's office and you make an application as that statutory creature to apply for a permit and an authorization, you are doing so as an officer of the corporate body under control of the public department. But and if you have absolute title, because on the registration documents you are put as first position, then your land is free from all estates and interest whatsoever, including the interest of His Majesty that are within the legislative jurisdiction of Ontario. So they use the Building Code enactment against you. They use the municipal enactment against you. And they claim because of these enactments, you must apply for a permit. Well, if you are the absolute title owner to your land, then you are free from the legislative jurisdiction of Ontario that have been set up by His Majesty. And as we saw, right, it is His Majesty that requires that we apply for a permit, that we apply for an authorization and that we pay for this right. Land Titles Act number 32. A parcel of land may be registered under this section with an absolute, possessory, qualified, or leasehold title. So four different titles upon the land, according to the circumstances as appears most appropriate to the land registrar. So when we go back up to 45, right, and we read it again, the first registration of a person as owner of land, we understand why it's written like that, because there's 4 types of registration that can go on that land. You can have absolute title, possessory title, qualified title, or leasehold title. Article 31. The council of any municipality to which this act applies may, by bylaw, authorize an application to be made to the land registrar to have any land that is within the municipality registered under this act. So the municipality makes an application to the land register concerning the land that you have bought, concerning the land that your house or your home is on. And the application that they make is to be considered the first registered owner of the land with absolute title. And this is where the evil and the wickedness of the legislative men and women who created these enactments in Canada and passed these enactments into law, and the Attorney General failing in their duty, that office failing in their duty to allow such a law to be put into existence in Canada to limit and abridge and to strip us of our human rights or natural rights. Now look here what it says. No consent required for the purpose of an application under subsection 1. So when the municipality applies to the land register to have your land registered within the municipality, registered under the act, for the purpose when they go and do that, the municipality shall be deemed to be the agent of the owners and other persons having an interest in the land designated in the bylaw, and it is not necessary to obtain the consent of such owners and other persons to the application. So the municipality can claim that they are operating as your agent, and as your agent they take absolute title for themselves, and they return to you a qualified title, and they don't have to tell you that they are doing such things. So in case anybody looks too hard, right, in the land registry, now they're going to go and fix this. Look what they do here. Article 46. The registration of a person as first registered owner. Oh, what are you complaining about, sir? You're the first registered owner. Look here in the land registry. It says you're the first registered owner. So what are you complaining about? Well, with a qualified title. With a qualified title, not absolute title. They don't allow you to register as first registered owner with an absolute title, but with a qualified title. And how can you tell? Well, the rest of this enactment, the rest of this article says what? Except that registration with a qualified title does not affect or prejudice the enforcement of any estate, right, or interest. So there it is, right? There it is right there. If you have a qualified title, then they can enforce the right or the interest of His Majesty against the title, against the land, and against the house. Article 46, subsection 2. The registered owner of land with a qualified title may apply to the land registrar to be registered as owners of the land with absolute title. That's your right. That's your provision. That's the measure in law that is there for you. The Provincial Offences Enactment. This is the enactment that each and every province uses to enforce their rules and regulations. So whether it's for a motor vehicle violation, whether for it's a municipality violation for not obtaining a permit, it starts in the original enactment and then flows into the provincial offenses enactment. And then from there, they will give you a fine or call you to court. So everything flows under this enactment. Everything that your person would be charged with would flow under this enactment. And Article 80 says common law defenses. Every rule and principle of the common law. So every rule and principle of the charter, or every rule and principle of our human rights that renders any circumstance a justification or an excuse for an act or a defense to a charge continues in force and applies in respect of offenses. So if they charge you with an offense under an enactment because you didn't get a permit, or if they charge you with another offense under another enactment, your common law rights, your human rights, gives you the justification, gives you the excuse, gives you the defense to the charge. Not if you just say so. You have to prove that the charge against you limits and abridges your human rights. The charge they laid against you was only created through the operation of law by limiting and abridging your human right. We find the same operation of law in the Criminal Code of Canada concerning disobedience to a statute, to an enactment, to a regulation. Every person who, without lawful excuse, contravenes an act of Parliament. So you have to have lawful excuse. You have to be invoking the principle of your human right. You have to be invoking the rules concerning your human right. And your human right produces a justification, an excuse, and a defense to the charge in respect of an offense they are trying to lay against you through a statute. And the Criminal Code recognizes the same thing. If you have a lawful excuse, then you are allowed to contravene the Act of Parliament. So on one hand, right, the Criminal Code and the police officers are under the control and under the presumption that you are an officer of the corporate body and you are in control by the public department, and they have the right to administer and enforce these statutes against you. But if you produce a lawful excuse, if you bring up the rules and the principles of your human rights, then you produce a lawful excuse, you produce a justification, you produce an excuse and a defense to any charge they would lay against you. And just to be clear, right, in the Interpretation Act of Canada, it teaches us that an act means an act of Parliament. And an enactment means an act or regulation. So when we go up to the Criminal Code and it says contravenes an act of Parliament, what they're saying is you contravene an enactment. You contravene a regulation. That's what you're contravening. The Emergencies Act of Canada, the preamble. And whereas the Governor and Council, in taking such temporary measures, would be subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights, and must have regard to the International Covenant on Civil and Political Rights. Well, why would a domestic government like Canada have to have regard to international covenants? Why would they have a controlling factor over Canada? Because that's the way it is. And that's how law is operating. Particularly with respect to those fundamental rights that are not to be limited or abridged even in a national emergency. So you have fundamental human rights that are never to be limited or abridged, not even in a national emergency. Now remember, right, in the Charter of Rights and Freedoms, Article 2, it says everyone has the fundamental freedoms. And then it lists these freedoms. But all of those freedoms can be limited and abridged. That's why here it says particularly with respect to those fundamental rights, not fundamental freedoms. Because fundamental freedoms under the Charter are freedoms given to a statutory creature, and they may be limited or abridged. But your fundamental rights, the rule of law says, they are never to be limited or abridged. And if they're using enactments and regulations and acts of parliaments to limit and abridge your human rights, then it is illegal, and you do not have to accept it. So even in the Criminal Code, Article 794, it says no exception, exemption, proviso, excuse, or qualification prescribed by law is required to be set out, as the case may be, in an information. So they are telling you, right, that if they're trying to charge you under a statute, or if they're trying to charge you under a regulation, that they don't have to include your lawful excuse, that they don't have to tell you that you have human rights that trumps their position. The burden of proving that an exception, exemption, proviso, excuse, or qualification prescribed by law and operates in favor of the defendant is on the defendant. It is up to you to bring forth the limitation and abridgment of your human right. Now look what it says. It says that this qualification, this exemption, is prescribed by law. It operates by law. It is provided by law. Well, what law are you talking about? You talking about statutory law? No, I'm talking about human rights. I'm talking about natural rights. I'm talking about common law rights. So because they have absolute title to your land, they apply taxes and levies against your property, and they require you to get permits and authorizations from them. And in the Criminal Code of Canada, right, you're considered to be a public store, and you're under the control of the public departments. So when the judge creates an order against your house, against your land, against your home, and the bailiff shows up to your house, and the police show up with the bailiff, they are all operating under the assumption and under the color of law that you are an officer of the corporate body, that you are at a residence and you are a resident, and you are subject to their orders. However, you are not subject to their orders if you produce your lawful excuse, if you invoke your human rights, then you change the playing field on them. They no longer can operate upon you as a statutory creature, but they must treat you as the man or the woman with natural rights, human rights that can never be limited or abridged. And this standing, this understanding is not imaginary. It is prescribed by law. It is the rule of law. It is primary law, foundational law, human rights